Yes, sir.
Good morning, Your Honors. My name is John Barlick. I represent the plaintiff appellant Richard Sisson in his capacity as administrator of the estate of Dawn Sisson, his late wife. The issue before the court, Your Honors, is, I believe, one of first impression in the Commonwealth. And that issue is whether the medical malpractice statute of repose, Chapter 260, Section 4, bars plaintiffs from recovering wrongful death damages where a tort action for medical malpractice is filed against this very defendant well within both the 3-year statute of limitations and the 7-year statute of repose, clearly alleging that the negligence would result in a premature death, and where the patient struggled to survive but eventually died 7 years and 4 months after the treatment in question.
Is that important, that it clearly alleged that one of the consequences would be premature death?
I believe it's the linchpin, Your Honor.
If it hadn't alleged that, if it just alleged malpractice, same occurrence, same facts, but without that, then statute of repose would have barred the wrongful death act?
I believe so, Your Honor, when one looks back to the purpose behind the statute of repose as enunciated by this court in Jocelyn versus Chang. In Jocelyn versus Chang, this court held that the object of a statute of repose is to, quote, suppress fraudulent and stale claims from springing up at great distances in time and surprising the parties when all the vouchers and evidence are lost, facts have been obscured by the lapse of time. In fact, Your Honors, that simply did not happen here. The amendment of the complaint following Dawn's death did not prejudice the defense nor surprise the defendants in any way. The defendants in their motion, and I believe the trial court, relied in part on the case of Rudenauer versus Zafiropoulos. I believe respectfully that reliance was misplaced. Rudenauer held that the statute of repose applies to medical malpractice wrongful death actions, and nothing more. That much is clear, and we concede. However, Rudenauer does not support the holding below because in Rudenauer, no medical malpractice suit of any kind was commenced before the statute of repose expired. And there the policy of preventing surprise and prejudice from stale claims was served. Here that policy is not served. The result was reached in Rudenauer, interestingly, by simply reading the express language of the statute. And we suggest that the same should be done here. In Rudenauer, there, quote, an action of tort for malpractice, unquote, to quote the repose statute, none was filed within 7 years. Here, by contrast, that, quote, action of tort for malpractice was filed within the repose period and fairly apprised the defendants of the allegations about that their negligence was causally connected to the premature death of Dawn Sisson. Now, significantly, Your Honors, we are not seeking an exemption from the statute of repose here because the cases are quite clear. There are no exemptions. We're not seeking a tolling of the repose period. What we're seeking is a holding that whereas here a malpractice action was timely commenced alleging premature death, the statute has been literally satisfied as to death actions. Again, harking back to the policy enunciated in Jocelyn.
Now, are there any category of damages that you'd be entitled to now if you prevail that you would not otherwise have been able to obtain had she lived?
I think that the measure might be slightly different. Had she lived brings up the very anomalous situation that had she survived until trial under both Glickich versus Spivak and a list of federal cases that we cite in our brief, she could have sued for economic damages due to her lost earning capacity from her upcoming premature death, assuming the proper expert testimony tying it in, and her children could recover for society and companionship due to the premature death. Now, while the wrongful death statute may provide a slightly different mechanism or quantum, and certainly a procedure, that is that the administrator is the only person who is standing to bring it, as explained by this court in Gaudet versus Webb, and I think it's a very instructive opinion from a global sense, it was kind of a revelation to me, because I've always parroted the nostrum that, well, actions for wrongful death didn't exist at common law. Well, in Gaudet, Your Honors straightened me out on that and said that from now on, the actions for wrongful death will no longer be regarded as creating a right to recovery, but just as requiring a slightly different measure of damages, that it be brought by the administrator, and that it's a limitation on the remedy and not upon the right. The reason I say that is because the fact that wrongful death existed at common law under Gaudet means that it existed in the ether, that there was not a distinct right created, and that if one adopts the rule that's urged by the defendants here, you get some very anomalous results. If the court will indulge me, I'd like to list 3 possible scenarios which would create very anomalous results. In case A, under the defense rule, the plaintiff files suit within 3 years of the negligence, alleging he will die prematurely. He dies, the complaint is amended before 7 years expire, no one would question there's a viable wrongful death action. Case B, plaintiff files suit within 3 years, alleging he will die prematurely, and does die, but 7 years and 1 day after the negligence. The defense would argue there can't be any wrongful death damages. Case C, what Justice Gantz referred to. Plaintiff files suit within 3 years, alleging he'll die prematurely. Plaintiff survives through trial. Under Glickich versus Spivak in the line of federal cases, there's no question that that plaintiff could seek damages for her shortened life expectancy. The interesting thing, Your Honors, is that in all 3 examples, the defendant was on notice from the outset of the allegation that the negligence would cause a premature death. However, in case B, the defendants contend that the defendant gets a get-out-of-jail-free card because the plaintiff had the poor judgment to survive for 7 years, but not all the way till trial. Okay. The statute of repose, I would submit, cannot have been intended to work in such an unprincipled manner. The principled test, which we would suggest must be whether the plaintiff commenced an action for medical malpractice within 7 years, which fairly put a defendant on notice that his negligence would cause a premature death. Now, mechanically, Your Honors, an alternative approach that brings you to the same place is to apply Rule 15C's relation back provision. Now, on its face, the rule would appear to apply here. However, as pointed out by my brother, in Tyndall versus Boston Housing Authority, in which this court declined to use 15C's relation back in an improvement to realty statute of repose case. But in Tyndall, and this is the critical distinction, the amendment after the statute of repose sought to add a new party defendant. And the policy behind the statute of repose was served by not allowing 15C's relation back. It would have surprised that new defendant.
If you could not have brought, you agree you could not have brought a wrongful death action before death occurred?
Styled as a wrongful death action, under the statute, I could not have.
But allowing Rule 15C relation back, you're essentially trying to accomplish the same thing by trying to institute a claim which was not, had not yet ripened.
I think, Your Honors, that only in the most metaphysical sense can one say that this wrongful death action is a separate claim, when we all agree that had the plaintiff or victim survived until trial, in substance, the same claim could have been brought for loss of future earnings, loss of society and companionship, derivative claims. I concede, Your Honor, that the procedural mechanism of the wrongful death statute would not have been available to us during her lifetime. But in substance, I believe that it's metaphysics at best. Here,
but it's statutory.
It is statutory, and I would have been fairly discouraged by that fact, but for the language in Gaudet versus Webb, recognizing that the statute doesn't create the remedy. It existed in the common law, in the ether, all the time, and that the statute simply prescribes how one goes about and measures these damages after someone's death.
Would it matter to you if there had been no consortium claims brought? because with wrongful death, there would be an award for essentially loss of consortium.
I think that under the case law relating to cases where a victim survives until trial but demonstrates a causal connection to a premature death, their derivative claims are also allowed there. Children and spouses can recover.
Right,
Analogous to Ferreter.
Right, my point is that you brought a consortium claim, but would it matter if you had not? If the wrongful death now expands the scope of damages to essentially the loss of consortium arising from the death?
Perhaps so. I'm glad I'm not in that situation, Your Honor. As you point out, we did bring the loss of consortium claim ab initio. Here, just to distinguish between Tyndall, we have the same defendants, so the purpose of the statute of repose of avoiding surprise and prejudice just isn't served. Significantly, the defendants point to no case in the Commonwealth in which 15C's relation back was denied as to the original defendants because of a statute of repose. I think the case law honors the theory and purpose behind it. There was an argument made in brief, and I suspect it will be raised today in argument by the defendants, that this statute of repose was part of an overall purpose to save on medical costs. And for that reason alone, this draconian result should obtain. I suggest, without being arch, Your Honors, that if one imposed a system where every new medical malpractice case were subjected to a coin toss test and every tails case summarily dismissed, that too would greatly save medical costs. But it would be neither fair nor principled. What the defendants urge here is neither fair nor principled, and despite the defendants having been put amply on notice of this premature death claim, it deprives families of a remedy because of the happenstance of when the victim actually dies. Significantly, Your Honor, imagine the implications of the defendant's suggested rule if the victim were on life support as the 7-year anniversary of the negligence approaches. If I were in that bed, surrounded by my dear, loved heirs, I'd keep a wary eye on the plug. It creates some terrible dynamics. And the illogic of it demonstrates that a principled solution has to be forged here.
Can I ask you, you argue, I guess, contend in your reply brief, that you essentially, there is essentially nothing left to this lawsuit after summary judgment was granted.
If I may explain, Your Honor.
Please.
Okay. This is a situation in which the true gravamen of the case from the outset was Dawn Sisson's prematurely ended life. She would have had to have surgery removing part of her leg, chemo, radiation, and suffered horribly for the remaining years, whether she survived or didn't survive. The real difference, and that which we had adduced expert testimony on, was that she was doomed by the delay here. It was particularly tragic and shocking, frankly, the timing of this, in that 2 years after the amendment was granted without objection to add the wrongful death claims, and 12 days before the start of trial, what was styled as a motion in limine was filed for the first time, trying to preclude us from proving a wrongful death claim. On the first day of trial, when we had our experts scheduled, all the demonstrative evidence in court, ready to prove that causal connection between negligence and death, the court essentially gutted our case. And my brother and I realized that. We worked with the trial judge to sever the wrongful death counts because we realized that this question would ultimately probably land us in this room. I would close, Your Honors, by noting that there is a principled solution to this issue, either through 15C's relation back or the plain language of the repose statute. The touchstone, as Justice Cordy pointed out at the outset, must be whether the same defendant was fairly and timely put on notice of a premature death claim, as in those cases outside the jurisdiction which we cited for their persuasive value, Price and the Wesley Chapel case. If I were to recite the actual language of a rule to be enunciated by this court, with all due respect, I would say, quote, where a plaintiff brings an action of contract or tort for malpractice, which fairly apprises the defendant that the alleged negligence will result in premature death, and that action is brought within 7 years of the negligent conduct, then the policy underlying the statute of repose has been satisfied, and the statute will not bar amendment to the complaint to comport with a wrongful death statute after the actual death, even if that death occurs after the repose period. For these reasons, then, Your Honor, I would respectfully pray that the court reverse the dismissal of counts 1 and 2 of the amended complaint and remand the matter for trial.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors. Charles Reddy. I represent Dr. Lhowe and Mass General Physicians Organization, and with due respect, we request the court to uphold the findings below. And not to digress here, my position in this case is this is a case of statutory interpretation, and that what this court is bound to do is to interpret the statute of repose basically in the nature that the court has interpreted the statute of repose in the decisions in the past.
Richard, your brother seems to be saying, if I understand him correctly, that although it's statutory, it's really nothing more than a codification of pre-existing common law, the door is open.
With all due respect, my brother is wrong. The Gaudet case, Judge Quirico was the author of the Gaudet case. And my reading of the Gaudet case, and it's an opinion, as many of Judge Quirico's were, that goes into the historical basis of what he did and why he did it. But I think what he said is that the cause of action, points that are important for this, cause of action for wrongful death accrues at the time of death. I think that's a point that's clear. That there's a separate cause of action that may be for conscious pain and suffering, which is separate from a cause of action for wrongful death. And that may be pursued after the plaintiff dies by her executor. That they are separate causes of action, and any right to recover based upon a claim of wrongful death is solely a creation of statute. That's the language of Gaudet. Now, if I may, Your Honor, and not to recast what counsel contends is the issue in this case, my view of the issue that this court has to reach in this case is whether or not this statute of repose precludes the addition of a new cause of action against an existing defendant where that cause of action doesn't arise until after the statute of repose period expires. That is what happened here. Now, if I may, I'd like to talk a very little history because I know that all the history is contained in the papers. But basically, this statute of repose was enacted as a result of this court's decision in Franklin and Albert, which was the discovery rule in medical malpractice cases. And what this court said at that point in time is that although there may be concern relative to not placing an outside limit on the time for bringing an action, this is going to be left to the legislature. And what happened is that the legislature took up that cudgel, and from 1980 up until 1986, when the statute of repose was passed, and the Jocelyn decision goes into that historical basis, that statute was enacted at that point in time. Now, if I may, and not to characterize all of the decisions as saying the same thing, but I think there's a basic nature relative to all of the decisions of this court interpreting the statute. The court has looked at the statute and determined that enforcement really is a rigid prohibition of an action, and that's consistent with the way the court has looked at this. That the statute of repose is not subject to any sort of equitable tolling, that it may impose hardship, that this court has indicated that a plaintiff who does not suffer the injury within the permitted time period by this statute may not be permitted to bring the action. What the statute of repose does is that it ends the cause of action as of that last date that the statute provides for. Now, there's no factual issue here. We know what the beginning date is. We know what the end date is, and there's no question that the date occurred, the death occurred after the statute had expired. There's no question that what was done by counsel was done in a timely fashion, but it was not timely in accordance with the statute of repose.
But why should we understand that the legislature intended this result? I mean, I understand that the legislature intended that a new claim not be brought against a doctor who had no notice of it more than 7 years after, but here the doctor certainly had notice in a timely fashion, and sadly the plaintiff dies, and if you're right, not only is there no wrongful death, but the loss of consortium claims of the children and the spouse are essentially lost.
Well, with all due respect, Your Honor, I disagree. The loss of consortium claims of the spouse and the children are viable claims through the time of Mrs. Sisson's death. Those claims survive. Those claims are claims that are still in existence. The claims that are expired would be the claims and the damages that would be recoverable under 229, which would be the loss of love, society, and affection that would have been suffered by those entitled to recover under the statute. So,
Say that again? I'm sorry. What claims have expired?
the only claims that expired were the claims that were made pursuant to the wrongful death statute. Under 229-2, those claims are the loss of the love, society, and affection, the reasonably expected net income that would have been received by those entitled to recover under the statute.
The medical malpractice claim and the loss of consortium claims are still alive. They're still pending.
They are still pending. They are still alive, Your Honor. The damages
So what kind of damages could one recover now under the medical malpractice claim, and who could recover it?
Let me make the assumption that this case was tried, back at the time that the judge made the decision that she made at the time, and counsel determined to
Try it
proceed.
right now. Why do we have to try it right now? What damages are recoverable, assuming malpractice is proven?
Well, are we assuming that the wrongful death action is part of the case or not part of the case?
Not part of the case.
Okay. Then what could be recovered is whatever pain and suffering Mrs. Sisson suffered relative to her disease and any alleged failure to diagnose it in a timely fashion from whatever point in time she began to suffer it up through and to the point in time of her death. Her husband and her children could recover whatever loss of consortium of the society and affection that she might have given them, that she was not able to give them because of that pain and suffering up to the point in time of her death. Those are damages that would be recoverable.
Nothing. Those are recoverable now.
That's correct, Your Honor.
Okay. Nothing else? Would something else have been recovered if she continued to survive?
Well, I know counsel mentioned Glicklick, and I'd be remiss if I didn't mention. Glicklick is an appeals court decision, a very well-written decision. But if the court would look at, I think it's footnote number 4 in the Glicklick case, Glicklick did not allow recovery while alive for the damages recoverable under the wrongful death statute. What Glicklick said is that the plaintiff could recover whatever damages she was entitled to recover for the period of whatever her life duration was based upon her disease up until the point of her death. She could recover for the apprehension that she might die. She could recover for pain and suffering that she might sustain. She could recover for any loss of earnings that she sustained as a result of her not being able to work up through her life expectancy. But the person, the decedent, is not the person who recovers under our wrongful death statute.
But moving to loss of consortium, if there had been a premature death claim and the jury were to have found that she would have lived for 30 years but is now going to live for 1, could the jury not have awarded a loss of consortium that would include the premature loss of their spouse or mother or father?
No, they could not, Your Honor. They could not award damages for 30 years. They could only award damages for the period of time that it was expected that the patient would survive. not for any period longer than
you're
that.
saying
Any
that-
period longer than that is the wrongful death
So
act.
you're saying the prematurity of death then is irrelevant to damages as to loss of consortium if the person survives?
It may not be irrelevant in the sense that the person, knowing that the person is dying, may suffer emotional damages associated with the knowledge that she may be dying, and those clearly would be recoverable through and including the time of her death. But, you know, I know that we might seem to be splitting hairs, but in a verdict form, in a malpractice case, when those cases are tried, if there is a claim for loss of conscious pain and suffering, damages recoverable while the patient was alive, damages recoverable by the estate, by those beneficiaries under the wrongful death claim after the patient has died. Those damages are separable damages because they are damages based upon separate and distinct causes of action. The cause of action that the patient had, that the plaintiff had, is not the cause of action for wrongful death. That cause of action doesn't arise until she dies. And to artificially say that under Rule 15 that could be deemed filed at a point in time when she wasn't dead runs aface of all that we are looking for in the law.
Well, we haven't faced this precise question, I guess. So let me ask this. What would Dr. Lhowe needed to have? What else would he need to know at this point? Or isn't he on notice of everything that the wrongful death action would give him notice of?
That's an excellent question, Your Honor. If the statute of repose provided that notice or knowledge would be something that would toll the effect of the statute.
No, I'm not talking about notice or knowledge. I'm really saying in the case such as this where there is knowledge given the state of her medical condition, just assume that there is that knowledge. They know she's going to die. The question is it 7 years plus 4 months, or is it 7 years from the date of filing, right? That's what we have here. Anticipating that, you file the action, and everything is in place, as far as I can understand, in terms of every element except the death. Every element of the claim that you would need for wrongful death has occurred except the fact of death. And so all the allegations of malpractice and on anything attended, all claimed, all available for discovery. Nothing more needs to be done given the allegation that death will ensue, right?
I agree with that, yes.
I don't know what to do with that information, but I
and let me
wonder if
suggest,
it's important.
you know, to be perfectly clear what my position is, that if statute of repose is construed the way this Court has construed it under the cases that appropriately construed it in the past, if it is, then in effect, at the end of 7 years from the date of the last treatment by Dr. Lhowe, whatever potential other causes of action that relate to any type of malpractice dealing with Dr. Lhowe expire because of that statute.
So that if the medical records of a doctor indicate that he or she knew that malpractice had been committed, and it is in the record, and it is also in the record that it will result in a premature death, and that is right in the record, but he never tells the patient or a member of the family, and that is in the record. Once the statute of repose expires, there's no claim.
Well, I think that is correct, Your Honor, and in looking at some of the cases that have been decided by this Court where that fact has been alleged, I think there are two cases, one in which a separate claim was made in which there was an intentional deception and a claim of fraud was made. And what the Court said is that the claim of fraud is outside the scope of this particular statute of repose because it is a claim separate and apart from a claim of malpractice. So this statute of repose would not relate to that. And we are getting somewhat afield from the situation in this case because that is not, as I understand it, the contention that was made by counsel and has never been the contention made by counsel. So it's...
But in those circumstances, could a wrongful death action be brought?
Potentially, it could not be under the decisions of this Court. And I'm not suggesting that the statute couldn't be amended to take care of this situation, but I truly believe that based upon what I have seen in the law, in the cases that I have reviewed, that has been considered to be a legislative function and not a judicial function.
Can I ask a further clarifying question? there's the 7-year period. Isn't there also another period post-death? Is there another filing?
It is, and you know, it can be a little bit confusing, and sometimes it's easier for me to understand it than to explain it, but basically, the statute of repose is the trump card. So it really doesn't make any difference that there might be, you know, a time period after the appointment of the administrator or executor that could be made. The trump card in this is the statute of repose.
But if we were to say, just if, that you could essentially, if you file such a claim as here, that you've met the 7-year period, is there another period that then would further cabin so you don't have a lifetime of potential claim?
I don't think so, but you know,
No?
at what point in time does it stop? And you know, one could.
You mean if she actually lives beyond 7 years and lives another 50?
That's right. Now, I don't know the answer to that, Your Honor. I think that's why the application of the court to this situation should be as the court has looked at it before. And under that application, my position is that the decision of the trial court was clearly correct, and that this action should be sustained. Thank you very much. I rely upon the brief or anything else that I'm sure that I didn't cover in my argument.
Thank you, sir.
Thank you.